We're live.
All right, we're back. Amron, thank you for being with us. I think it would be helpful for us, we've heard some testimony on the bill, and I think it would be helpful just to go through the first sections of the bill, the sections that are really more relevant to our committee, so we can understand exactly what's happening. I don't know that we're going to be able to resolve differences around whether or not this is going to detract from nurses who are in the state and work in the state as compared with the availability of travelers. So, but at least we can get a good grip on and grasp of what is actually in the bill. So if you don't mind going through the bill, it doesn't have to be at the 2-foot level, but a little more than 10,000 feet would be helpful.
Certainly. For the record, Amron Aberjali from the Office of Legislative Counsel.
Do you want to put the bill up?
I can do that.
All right,
Yes.
that'd be good. And committee, again, if you have questions, just speak up because I can't always see all of you.
Can you see the bill right now?
Not yet. We can see
Okay.
the documents and handouts page.
Okay. I tried to move my screen and that created a problem. Just one moment.
We do have it. If you have difficulty, we can just look at it.
I'm having a
All right, let's
issue with my two screens. I think I should be able to do it now.
all right.
How is that? Can everyone see that?
Yes.
Okay, great. So let's see. I'm going to move past the findings and declarations to more of the meat of the bill. And past the definitions. So down here, we're looking at general provisions and jurisdiction. This is the section that outlines how a resident of the home state may apply for a multi-state license to practice as a registered or licensed practical or vocational nurse within any party state to the compact. The state, as in the home state, must implement procedures for considering the criminal history, records of applicants for initial multi-state license or licensure by endorsement. And as we heard from the Office of Professional Regulation before, we would not need to redo the criminal history FBI background check if someone were to already have had a multi-state license within another home state and they're simply moving the residence to Vermont. Each party state shall require there's a set of requirements for each applicant, and those are outlined here at the bottom of page 6 and into page 7. We've discussed those briefly. The applicant must meet the home state's qualifications for licensure or renewal of licensure, as well as all other applicable state laws. The applicant must have graduated or is eligible to graduate from a licensing board approved RN or LPN-VN pre-licensure education program, or have graduated from a foreign RN or LPN-VN pre-licensure education program. And the applicant must have been a graduate of a foreign, or they could have been a graduate from a foreign pre-licensure education program, but if it was not taught in English, or if English was not the applicant's native language, they must have successfully passed an English proficiency examination. The applicant must have successfully passed the NCLEX-RN or NCLEX-PN examination or recognized predecessor. The applicant must be eligible for or hold an active unencumbered license. And as we also heard from OPR there, we're looking at whether the person's current license is unencumbered. That's not to say that they might not have had issues of adverse actions on their license previously, but if they have, those have been resolved and their current license is active and unencumbered. The applicant has submitted, in connection with their application for initial licensure, fingerprints or other biometric data for the purpose of obtaining criminal history record information from the FBI and the agency responsible for retaining that state's criminal records. The applicant must not have been convicted or found guilty of a felony offense under applicable state or federal law, and has not been convicted or found guilty of a misdemeanor offense related to the practice of nursing as determined on a case-by-case basis. The applicant is not currently enrolled in an alternative program. The applicant is subject to self-disclosure requirements regarding current participation in an alternative program, and the applicant has a valid U.S. Social Security number. Any questions before we move on into a new section here?
Looks like we're good.
Okay. So an important note here, all party states, that is all states that are party to this compact, shall be authorized in accordance with their own state due process law to take adverse action against a nurse's multi-state licensure privilege. And that could include revocation, suspension, probation, or any other action that affects a nurse's authorization to practice under a multi-state licensure privilege, including cease and desist actions. If a party state takes such action, it shall promptly notify the administrator of the Coordinated Licensure Information System. And then the administrator of the Coordinated Licensure Information System shall promptly notify the home state of any such actions by remote states. Any questions around that? A nurse practicing in a party state must comply with the state practice laws of the state in which the client is located at the time service is provided. It's important to note the practice of nursing is not limited to patient care, but shall include all nursing practice as defined by the state practice law of the state in which the client is located. The practice of nursing in a party state under a multi-state licensure privilege will subject a nurse to the jurisdiction of the licensing board, the courts, and the laws of the party state in which the client is located at the time of service. Moving down to subsection F, individuals not residing in a party state shall continue to be able to apply for a party's single state license as provided under the laws of each party state. However, the single state license granted to these individuals will not be recognized as granting the privilege to practice nursing in any other party state. And nothing in the compact will affect the requirements established by a party state for the issuance of a single state license. Subsection G, any nurse holding a home state multi-state license on the effective date of this compact may retain and renew the multi-state license issued by the nurse's then current home state, provided that a nurse who changes primary state of residence after this compact's effective date must meet all applicable requirements of subsection C of this section to obtain a multi-state license from a new home state. A nurse who fails to satisfy the multi-state license requirements in subsection C due to a disqualifying event occurring after this compact's effective date shall be ineligible to retain or renew a multi-state license. And the nurse's multi-state license shall be revoked or deactivated in accordance with applicable rules adopted by the Interstate Commission of Nurse Licensure Compact Administrators. Any questions before I move into a new section?
Sounds good.
All right. Applications for licensure in a party state. Upon application for a multi-state license, the licensing board in the issuing state must ascertain through the information system whether the applicant has ever held or is the holder of a license issued by any other state, and whether there are any encumbrances or any license or multi-state licensure privilege held by the applicant, and whether there's been any adverse action that has been taken against any license or multi-state licensure privilege held by the applicant. And lastly, whether the applicant is currently participating in an alternative program. An important note here, a nurse may only hold a multi-state license issued by the home state in only one party state at a time. If a nurse changes primary state of residence by moving between two party states, the nurse must apply for licensure in the new home state, and the multi-state license issued by the prior home state will be deactivated in accordance with applicable rules adopted by the Commission. The nurse may apply for licensure in advance of a change in primary state of residence. A multi-state license shall not be issued by the new home state until the nurse provides satisfactory evidence of a change in primary state of residence to the new home state and satisfies all applicable requirements to obtain a multi-state license from the new home state. If a nurse changes primary state of residence by moving from a party state to a non-party state, the multi-state license issued by the prior home state will convert to a single state license, valid only in the former home state. And there are some additional authorities for party state licensing boards. So in addition to any other powers conferred upon a licensing board by state law, this compact gives a licensing board the authority to take adverse action against a nurse's multi-state licensure privilege to practice within that party state. Only the home state shall have the power to take adverse action against the nurse's license issued by the home state. For purposes of taking adverse action, the home state licensing board shall give the same priority in effect to reported conduct received from a remote state as if such conduct had occurred within the home state. In doing so, the home state shall apply its own state laws to determine appropriate action. The licensing board may also issue cease and desist orders or impose encumbrances on a nurse's authority to practice within that party state. Moving on to page 12, complete any pending investigations of a nurse who changes primary state of residence during the course of an investigation. Issue subpoenas for both hearings and investigations that require the attendance and testimony of witnesses, as well as the production of evidence. Obtain and submit for each nurse licensure applicant fingerprint or other biometric-based information to the Federal Bureau of Investigation for criminal background checks, and may use the results in making licensure decisions. If otherwise permitted by state law, recover from the affected nurse the costs of investigations or disposition of cases. Take adverse action on the factual findings of a remote state, provided that the licensing board follows its own procedures for taking such adverse action. If adverse action is taken by the home state against a nurse's multi-state license, the nurse's multi-state licensure privilege to practice in all other party states shall be deactivated until all encumbrances have been removed from the multi-state license. Let's see. Okay, and nothing in this compact shall override a party state's decision that participation in an alternative program may be used in lieu of adverse action. The home state licensing board shall deactivate the multi-state licensure privilege under the multi-state license of any nurse for the duration of the nurse's participation in an alternative program. Now we're moving into the information system, the coordinated licensure information system. Is this an appropriate level of depth, Madam Chair, or would you like me to go higher level or?
I think we're
lower
getting
level?
we're getting to a place where you can go higher level.
Okay.
Yeah,
Perfect.
and the questions that we have still remain regarding the cost to the state, and as well as the traveling nurse issue. And so it would be good if we could finish up within just, like 5 or 10 minutes and then have a very brief discussion.
Sure. I
Okay.
will
Just
move more
within,
high level.
yeah, and we don't need to go through the entire bill because there are sections that relate more to GovOps that we'll be asking them to evaluate.
Perfect. All right, so the Coordinated Licensure Information System, as you may recall, all party states have to participate in the Coordinated Licensure Information System. The Commission has established rules over what needs to go into the information system and has procedures for the identification, collection, and exchange of information. All licensing boards within the party states are required to report certain information within the system related to adverse action, usually, and other licensure denials. Some of those, the required reporting is outlined in the rules. It's important to note that all party states, including information, are required to put in information that may be confidential under their state law, but it's important to note that they can designate in the system when that information can be shared or not shared with non-party states or other entities. They're not going to share any personally identifiable information with non-party states. Any information that would be expunged under state law would be expunged from the system also. As I said, the rules for the compact have outlined the specific information that needs to be submitted by party states. The compact administrator for each party state is the one responsible for providing the documents and information into the system. And there is established the Interstate Commission of Nurse Licensure Compact Administrators. This is the section that outlines all of the powers and duties of the commission, outlines membership and voting, and how meetings would take place, what types of meetings could be conducted behind closed doors. All meetings shall be open to the public unless they meet certain criteria to be conducted behind closed doors. And those tend to be closed door meetings similar to what our open meeting law would consider to be appropriate for behind closed doors. Moving down through to page 19. The commission is really run by the administrators. Each state has one administrator from their licensing board. And that administrator would be part of the commission that votes to prescribe bylaws and rules to govern its conduct. Some of those duties and powers of the commission are things like establishing the fiscal year of the commission, providing standards and procedures, outlining conduct for meetings and when meetings occur.
So I think we've gotten into the GovOps sections, even though each one of us has had significant experience with meetings and protocol. But I think why don't we end going through the bill at this point? And I'd like to have a short discussion with folks on this. But Amren, don't go away.
Madam Chair, if I might add one more thing.
Please,
the
yes.
last section of the bill, I'm going to skip down to that. That is one section that might be worth looking at, because this is specific to Vermont. And just to go over what the Board of Nursing, just to mention, right, that the Board of Nursing shall have the power to oversee the compact and recover from nurses practicing the costs of litigation and investigation. That will be the entity responsible for conducting a background check prior to issuing a multi-state license, including a fingerprint background check. The executive director of the Vermont Board of Nursing, or designee, is the one that would be the administrator for the Nurse Licensure Compact. And the Vermont State Board of Nursing may adopt rules necessary to implement and enforce provisions of this subchapter and take disciplinary action against the practice privilege of a nurse practicing in the state under the compact. Just wanted to make sure that that is on your radar. This is language that Vermont, that is specific to Vermont. This is not the standard compact language. So I just wanted to make sure that this was on your radar. I know there were some questions about what the administrator can and can't do. And so here's where the Vermont Board of Nursing may adopt rules around implementing and enforcing the compact. Okay. And lastly, to note that this will take effect on February 1st, 2022.
Okay, good. Why don't we pull that off of the screen, and then I'm going to ask a couple questions. Let me just get it going here. The issue, one of the issues that we've heard about, obviously, is the cost, how much the state may or may not lose as a result of licenses. Then the question about how much it costs to be a member. So we'll have that fiscal note renewed. There are also questions about the background checks, and that we did hear from OPR that they do that now. So there's something in place, but will that add extra cost? Then I have another question, and I don't know whether, Ameren, you can answer this or not. Do we know if we can regulate traveling nurses by saying that compact nurses would be considered as in-state licensed nurses and not, I don't know how to word it, but the issue now for traveling nurses is that they're extremely expensive, and it puts a huge burden on our healthcare system. Hospitals are spending a lot of money and to various organizations to bring travelers in. Do we have any avenue for regulating that if and when we become part of the compact? I guess that's the broader question. And I throw it out there as a question, and I think it's something we might be able to look at, and maybe Jen Carby can help with that. I don't know.
Let me just make sure I understand the question. So would you be able to treat nurses who would normally be considered travelers as non-travelers if they hold a multi-state license?
That's
and
a
we
good
were
way
part
of
of the
putting it.
compact.
Yeah, that's a
Okay.
good way of putting it. I mean, potentially, the potential for having people travel out of state because they can earn more money as a traveler is, I think, I don't imagine a whole lot of nurses who have a full-time position in our state would do that, but we don't know what it means. And we don't know what it means for bringing travelers into the state. And that's been brought up time and again. So, so then committee, the question I have, and I know Ruth, you had your hand up, Senator Hardy, you had your hand up, and I do want to have you ask your question first, but just basically, how are we feeling about the bill in terms of a workforce improvement bill and helping our nursing workforce? That's the general question. But so Ruth, you have a question.
Yeah, I have a couple questions, Ameren. That basically everything in this bill has to stay as it is in order for us to participate in the compact. So we have pretty limited ability to make changes, except for maybe in that final section that you noted about Vermont's role. Is that right?
That's correct.
Okay. And do you know, I do think there's OPR mentioned in their testimony that there is a change in the background checks for nurses. And I don't know, maybe we don't currently require a fingerprint, and this does require a fingerprint. Is that I see Senator Lyons nodding her head.
Yeah, there is a difference. You're absolutely right. There is a difference. And so is there a cost associated with that? I guess is the question.
Yeah, so the logistics and the cost, because the fingerprint is more of a bigger deal, whatever. And I'm happy to hear the chair say that we'll have a fiscal note, because that's my biggest concern. I think I'm very supportive of us doing this. In terms of the traveling nurse thing, I think we're not sure what the impact is. It could have some positive and negative impacts on the whole quote unquote traveling nurses problem. But the fact will still remain that we have a nursing shortage and traveling nurses get paid so much because they come in
Because we have a shortage.
because we have a shortage. So I don't know that this will impact that hugely, but it's from hearing from our nurse educators, they're saying that nursing students really would value this, and that may help more people go into nursing. And so I think, overall, I'm really supportive. I'd like to understand the fiscal impact more in terms of the $1 million decrease in out-of-state license fees and how we might need to fill that hole. But I think we should move this forward when we can.
Okay, so I think what I'm hearing you say is, let's get the fiscal note, and then let's see what we can do to move it forward. Senator Cummings. You're muted, Senator. You know what? As soon as we end Zoom, everybody's going to be so happy.
I think we need to do this because this is the future and we're about to be left behind. But I think if anyone benefits, it's going to be the traveling nurses, because they won't need to get a license in Vermont, which they do now, to practice here. And that's where the $1 million loss is coming from. The one concern I have, and I'd like to flag it when we send this to GovOps, is the ability of the compact board to incur debt, and the ability of one appointed person to agree to incur debt that the state of Vermont is then liable for, if it's incurred while we are a member of the compact. And I'd like to be able to put a fence around that on our end. No one else that I can think of in the state can incur debt without any limit or any oversight.
So I think that's our job. I think we can do that. I don't think, because it's my understanding that GovOps will look at this in the same way they did last time. It won't be going into the committee, but they'll be looking at it while it's here. And so we can have them answer that question, and maybe help us draft the fence, because I agree with you. That is very problematic. So Amarin, do you know from your understanding of the compact itself, can we draw this fence? And then if so, how? I mean, I think it's almost mandatory that we draw the fence. How can we draw it? I guess we're looking for some help and some language that might require an additional step before X amount of debt is incurred. And I don't know if we name the amount, Senator Cummings, or if we simply say it's a step for any amount of debt incurred by the state. Can we do that within this compact?
That's our regulation of we can't say they can't incur debt, because that's their regulation.
It's their regulation, exactly.
Yeah. But I think we can say that over a certain amount or any debt would have to get the approval of the Joint Fiscal Committee, which is what we do with grants that imply debt, or the governor, but somebody should have a veto. If it's $2,000 worth of debt or $20,000 to cover payroll till the dues come in, that's one thing. But if it's $20,000 a month for the next 30 years to pay for a new building, we could be long gone and still out of the compact and still paying that debt. I mean, there needs to be some limit, and maybe we could ask the, what is he, Commissioner of Finance and for the administration, if they have any thoughts on this.
Okay. Senator Hardy.
Yeah, I think if we can draw a line, that's great. I think, and important. However, I don't see this as a huge potential for, long-term debt. I think there's one paid staff member. So I don't know that they would be
Now,
building a huge office. Well, there are 35 states in it already. So I don't think this is a sort of empire building kind of organization. And I agree that, if we can put some language in, the rule maybe specific to say that the rules need to be made about this. But I think that the risk is fairly low, except for maybe to cover payroll kind of thing. But even still, it's payroll for one person. So I think it's
Okay.
low risk.
okay, this is good. I think, so Senator Hooker, you wanted to comment on this issue?
Actually, I wanted to go on to a different one, so finish your thought about,
Okay, so we've come up against our time limit, but go ahead, let us know what
Uh,
it is, and then,
just quickly about the fact that we haven't been able to get traveling nurses even during the pandemic because of the pay scale that we have. So what is this going to do to make our pay scales are commensurate with other compact states?
nothing. It probably won't have an effect unless we do something to help the pay scale along. Okay, so Amran, you have heard the comments from the committee in terms of a possible fence around the bonding capacity within the compact, or rulemaking that we might have in state that would provide that guidance. Give us your best thoughts on that. And I won't ask you to do that right now because we're out of time, but let's come back to this one, and we'll also come back with a fiscal note. We'll put a request in for a fiscal note with Nolan. Okay.
Yes.
Thank you for today. Thank you all for today. The issues that we are beginning to cover do carry some controversy, and I appreciate that. And we'll try to get the information that we need to get to a vote on some of these bills. So thank you. I'll see you all tomorrow at 8:30. At 8:30. Tomorrow we're meeting at 8:30. All right, Nellie, we can go.
Jenny, I said